Hello friends, in the series on income tax cases, today we will discuss a case in which the issue before Delhi ITAT G bench was that if the assessee makes some investment for the purpose of his business and those investments have a proximate and direct nexus with the business of the assessee, and if the assessee loses those investments, so whether in that case the loss on account of those investments should be allowed to the assessee as business loss under section 28. This issue has been taken up by Delhi ITAT G bench in the case of Assistant Commissioner of Income Tax versus Span India Private Limited, and this case is reported in 128 ITR Tribunal at page number 536. The date of the judgment is 4th March 2024. In the present case, the facts of the case are like this. The assessee has made some investments. Those investments become bad, and it was very clear from the facts of the case that those investments were having a direct and proximate relation with the business of the assessee. When the assessment proceedings were going on, the learned assessing officer was of the considered view that these the loss on account of diminution in the value of the investment should not be allowed to the assessee, because that investments have not been taken specifically into the income of the assessee. So that loss of investment should not be allowed to the assessee by invoking section 36 subsection 2. Per contra, it was the submission of the assessee that when the income is taxed, then the loss relating to that business should also be allowed to the assessee. When the matter was before the tribunal, because the assessing officer disallowed the loss, so when the tribunal heard the matter, the tribunal said that there is a difference between business loss and business expenditure. Expense is a conscious charge, while the loss arises from the regular operation of the assessee. The tribunal said that the loss should have direct and proximate relation with the business, which in the present case is there. The tribunal said that if the profit is to be taxed, then any loss which is directly related to the business of the assessee, that should be allowed. The tribunal was also of the view that some expenses are specifically allowed to the assessee in the series section 30 to section 36, and if some expenses are not falling in that category, then those expenses are allowed in a general provision, that is section 37, subject to that those expenses are wholly and exclusively for the purpose of the business. Those expenses are not personal. Those expenses are not of capital expenditure. Apart from that, the loss must be allowed to the assessee if that loss has or incidental to the business of the assessee. So the tribunal allowed the business loss on account of diminution in the value of the investments to the assessee under section 28. Apart from that, in the present case, the assessing officer has also invoked section 14A and applied the formula for the disallowance of the expenses in relation to the exempt income. For that, the tribunal said that in the present case, the AO has failed to follow the procedural aspect of invocation of section 14A subsection 2. The procedural aspect says that if the assessee makes some disallowance suo motu, then the assessing officer has to record a satisfaction that that disallowance is not justified and give the reason that why the assessing officer is going to invoke section 14A rule 8D. The tribunal said that there was no such a thing of deemed satisfaction or an employed dissatisfaction while invoking the provisions of section 14A subsection 2 of the Act. Friends, it has been seen that whenever there are investments into the balance sheet of the assessee, the assessing officer, without going heed or without giving any attention to the disallowance which has been suo motu made by the assessee, invokes section 14A rule 8D, which is not the right procedure. The right procedure is that the AO has to give comment or counter the suo motu disallowance made by the assessee, then he can move to the rule 8D. At the end of this video, once again I am repeating the name of the case. The name of the case is Assistant Commissioner of Income Tax versus Span India Private Limited, and this case is reported in 128 ITR Tribunal at page number 536, and the date of the judgment is 4th March 2024. Thank you, friends.